5 seconds. The appeals by special leave are from the judgment of the High Court of Punjab and Haryana in CWP numbers 5629, 5630 and 5631 of 1984 dated July 23, 1993. The respondent, while was working as a selection grade superintendent in the High Court of Punjab and Haryana, had attained his superannuation after reaching 58 years of age on August 31, 1980. The Chief Justice of the High Court had extended his tenure by 2 years and thereby he was to retire after the expiry of re-employment period of August 31, 1982. During his re-employment, it had come to the knowledge of the Chief Justice that the respondent had committed misconduct of embezzling the funds of the High Court. Therefore, he was kept under suspicion on December 17, 1981 and a charge sheet was issued after enlistment of the three specific charges against the respondent on the grave charges of embezzlement. On expiry of 2 years, he was allowed to retire after conducting the enquiry by the district judge and on receipt of the report in that behalf, complying with clause 2 of article 311 of the Constitution and the relevant statutory rules. The Chief Justice of the administrative side dismissed the respondent from service by his orders dated June 7, 1983 and August 31, 1983 with immediate effect. On appeal as per the rules, the division bench on the administrative side confirmed the order on January 24, 1984. The respondent challenged the orders in three civil writ petition numbers 5629, 5630 and 563184. The division bench by judgment dated July 23, 1993 declared thus: it is seen that the learned Chief Justice of the High Court on the administrative side, while passing the order of dismissal, agreed with the inquiry officers finding that the respondent committed embezzlement and mentioned that the order of dismissal would come into immediate effect from the date of the order. In other words, he appears to have intended to say that the order of dismissal will be operative from the date of the order of the dismissal, but it would appear that the Chief Justice was not apprised that the delinquent had already been retired from service on completion of 2 years period of extended service of re-employment with effect from August 31, 1982. Therefore, the order of giving effect to the order of dismissal from the date of its order was of no consequence and became superfluous as he was no longer in service as on that date. However, it would be clear that he has the power either under Rule 2.2 of the Punjab and Haryana Civil Service Manual Volume 2 or Rule 9 of the Central Civil Services Pension Rules to take appropriate action as was made applicable to the staff of the High Court of Punjab and Haryana as the case may be. Therefore, it would be open to him to take such action as is open to him under law, the impugned order of the High Court is set aside and the writs are issued with the above modification. The appeals are allowed no costs.